Thank you all for your patience in resolving these tech issues. Like I mentioned, this is something that courts across the country and across the globe are dealing with since we're now trying to work through a global pandemic. And so just know that the Supreme Court and the Court of Appeal and all courts are kind of dealing with this right now, and you're also experiencing that. So good morning. You've joined a virtual courtroom in Osgoode Hall to conduct the hearing for Archibald and Ontario. We have all parties, including the judiciary, participating by video. Please be mindful that the judiciary may be relying entirely on electronic records, so when you refer to a particular passage or paragraph in your submissions, please afford some extra time for the judiciary to find it before continuing on. It's common to be reading notes as part of your submissions. When doing so, please try to glance at your screen periodically, as the judiciary might try to raise their hand to interject and ask a question. When not providing submissions, as a best practice, please place yourself on mute in order to minimize background sounds. And as a reminder, at our level of court, we do not address the judiciary as Your Honor, but address them by name. I will introduce your panel. The president of the panel is Justice Thorburn, joined by Justice Lickwernick and Justice Siskorio. I will now turn the courtroom over to the president of the panel, Justice Thorburn.
Good morning, everyone. We are here for the matter that we've just been discussing, and so I look forward to hearing the submissions from all of the parties. I guess we will begin with the appellant's case. I'm going to remind you that there are strict time provisions that have been allotted, and without further ado, we look forward to hearing from you.
Good morning, Justice Thorburn, Justice Lickwernick, and Justice Siskorio. My name is Heather, initial A, and together with my co-counsel, Shah, initial A, and Shripathy, initial V, we will be presenting an appeal in this case on behalf of the appellant, Ms. Archibald. Within the scope of this oral argument, there are a number of points we would like to highlight from our submitted factum. While the court acknowledged there was historical injustice and persecution faced by Indigenous groups in Canada, they ruled that the decision by the director in this particular case could not be seen as discriminatory. We would submit that these points in challenge to the court's reasoning. 1. That the impact of the decision on the Deer River people must take into account the historical harm inflicted upon Indigenous people and the structural injustice that still exists as a result. 2. That the decision directly and foreseeably perpetuated and exasperated centuries of a disadvantage by failing to account for circumstances particular to Indigenous populations and residents in Canada. The court then ruled that the director's decision had no infringement on Ms. Archibald's rights to life and security of the person, on account of finding insufficient evidence that the director's decision in particular inflicts charter-infringing harm upon Ms. Archibald, and that regardless, Ms. Archibald was requesting a positive right not granted by Section 7 in her case. We submit these points in challenge. 1. That given the circumstances, the court held our client to an unreasonable standard of evidence to demonstrate harm. 2. That our best available evidence demonstrates that additional benzene does in fact exacerbate the harmful health effects of pre-existing pollution. 3. That what Ms. Archibald is demanding is much closer to a protection against deliberate government action, i.e. a negative right, rather than a positive demand for government protection. Finally, we believe that if Section 1 was applied using the standard established in Dore v. Quebec, the court would have ruled in favor of the appellant. The director failed to rationally balance the economic health of the community with its environmental and public health needs. They erred in their interpretation of economic necessity, placing speculative economic suppositions of the clear and present risk to the health of Ms. Archibald and the Deer River First Nation. It is the responsibility of administrative decision makers to integrate charter factors into their analysis, and should this court absolve the director's decision to disregard and aggravate decades of chronic disease and generational trauma in favor of ensuring short-term profit for a corporation, it will have dealt a substantial blow to this doctrine and sanctified institutional discrimination under the guise of economic necessity. We ask that you allow this appeal and reverse the director's decision. I yield to my co-counsel.
Are we beginning with Ms. Shaw?
Sorry, let me just get the technical side figured out on my end. I apologize. Could everyone see and hear me?
Yes.
Yes.
Okay, thank you. A full and detailed discussion of our arguments addressing the two-part test for discrimination could be found in our factum. However, for the purposes of this appeal, we would like to address some points brought up by our friends in their factum and to highlight a couple of points of importance in our own. We first call attention to two claims our friends have made. First, the director's decision does not create a distinction as it affects the non-reserve residents of the St. Pierre locale as well as the Deer River Reserve. Second, the appellant must demonstrate discriminatory effect or intent. With regards to the first point, we submit 2 points. First, policies that target groups that are disproportionately, even if not entirely, members of a Section 15 protected class could still be considered discriminatory. Indeed, the mechanism by which most structural discrimination operates is through such statistical or indirect discrimination rather than prima facie discriminatory policy. Second, regardless, the unique circumstances of reserve residents still render the director's decision discriminatory. With regards to the second point, we submit 2 points. First, the perpetuation of prejudice or stereotyping is not the test by which the court determines whether or not a policy is discriminatory, but rather one of the many mechanisms by which one could be used to show discrimination. Second, the court has traditionally taken a context-based approach to determining the presence of discrimination. We submit here that the doctrine of adverse effect applies, wherein a policy may be facially neutral, but nonetheless be considered discriminatory because it perpetuates disadvantage or causes disproportionate harm upon a protected group due to its social and historical context. This approach to discrimination has been articulated by cases brought before the Supreme Court, such as in Quebec VA and RB Cap.
Counsel, I have a question for you. Sorry,
yes.
Thank you. I have a question for you. Does the type of disadvantage that's being perpetuated, does it have to have a link to the type of disadvantage that was felt historically by the group? So I know that in this case, we're dealing with health consequences. Is there evidence of Indigenous groups facing health consequences as a result of governmental actions? And if there's no evidence of that, do we need that type of evidence? Does it have to be the same type of discrimination being perpetrated over and over again?
Okay, so we think that, like, historically the court, like, it usually does have to be the same type of discrimination. We think that, like, we do have evidence of health consequences being perpetuated by the government. That is in our factum. Second, we tell you that, like, there is even if you don't accept that, there's also an element of cultural discrimination that I will be addressing later in my arguments. The specific connection of health consequences will be discussed by my partner.
Sorry, you said cultural discrimination?
Yes. So
is there charter protection for cultural discrimination?
If you would like, I will elaborate more on that point if you would let me skip ahead. Well, sure. I'm sorry, I shall skip ahead. Okay, so the cultural context in which First Nations group exists is that the Canadian government has engaged in a centuries-long campaign of removal, persecution, and cultural genocide against the First Nations people.
But I guess my question is a little bit different. Is there charter protection for cultural discrimination?
we believe cultural discrimination is not a specific doctrine that we are invoking, but rather a word I am currently using to refer to a whole set of possibly discriminatory policies. I think that it will become more clear once I elaborate upon the cultural context and upon the discrimination faced. Okay, so I think like moving ahead to that section, the Canadian government has engaged in a centuries-long campaign of removal, persecution, and cultural genocide against the First Nations people, resulting in many facing both cultural trauma and economic disadvantage. This has left reserves as one of the few places where First Nations peoples may form communities, continue their traditions, and practice their cultures. The importance of the reserves as a safe haven for First Nations people has been recognized as a part of Canadian First Nations policy and is the basis upon which we submit reserve residents as protected ground. Because of historical discriminatory policy, unreserved residence is vital to the culture and way of life of the Deer River people, and an abridgment of safe residence on the reserve is itself a perpetuation of historical discriminatory policy. That is the full argument by which we submit the point of cultural discrimination. We think that First Nations people face historical disadvantage in their ability to practice their culture and way of life due to literal cultural genocide. And we believe that not harming their ability to feel safe in their reserve is vital to the protection of culture. Would you like me to continue on?
Yes, please. Yes, please. That's great.
Okay. I think the 2 points of historical context are of importance here. The first I already gave with regards to the cultural history of the First Nations people, but second, First Nations communities have historically faced environmental disadvantage in particular. This is true of the Deer River First Nations, who have experienced the harmful effects of decades of benzene exposure. And because the point of it being the same vein of discrimination has been brought up, we've pointed out that there is evidence of ministerial or government environmental discrimination. We point to the reluctance of the ministry to perform studies on the health effects of First Nations communities living in the chemical valley, so that they could provide make policies agnostic to the health effects of the chemical pollution. My partner will bring this up more as an example. But second, we tell you that because of already existing harms to the body and health of the Deer River First Nations who are living in this high benzene zone, as well as inequality to access to economic opportunity and healthcare. This is a mode of health discrimination perpetuated by the government. The health shock from the additional benzene exposure would have a much greater effect and be much less likely, they would be much less likely to endure such a health shock. We believe that this exacerbates already existing disadvantage. But finally, we believe that the director as a ministry decision maker has the duty to be aware of and consider the historical context in her decision. And by weighing what amounts to a 5% reduction in labor force over the health and life of Deer River's people, we submit that she has not. So a full analysis of how the director's policy connects to harms caused to Deer River First people will be done by my partner under Section 7. But in assessment of my own and my co-counsel's analysis, we would request that the panel keep in mind the nature of administrative decision-making is that the decision-maker is afforded a massive amount of discretion with very little oversight or paper record. This allows the ministry to sanitize the decision-making process and to present only the final result of said process. We implore the court to keep in mind the historical context and the presence of structural discrimination when considering the arguments and evidence presented, and to not let a lack of transparency be a proxy for blamelessness. Thank you.
Sorry, not let a lack of transparency be what?
A proxy for blamelessness.
Blamelessness, thank you.
Can everyone hear me?
Yes.
Good morning, Justices. My name is Sripathi, initial V, and I am appearing for the appellant. I will be detailing our submission with regards to issue 2. First, I will be discussing how the director's decision does in fact lead to harm, proving that Ms. Archibald's Section 7 rights are indeed infringed, and that scientifically rigorous proof as to whether or not the benzene has caused these effects is unreasonable. Finally, I will submit why this infringement is not in line with principles of fundamental justice, specifically the principles of substantive fundamental justice. In paragraph 60 of our factum, we stated that the infringement on the right to life in this case must prove a causal connection between the risk of harm or harm asserted, as established by Lockridge v. Ontario. Without performing longitudinal studies related to benzene-specific harm, there's no actual way to prove that these harmful effects that Ms. Archibald has suffered from were caused by benzene. But our main concern here is that if RUCAN is able to emit an unregulated amount of benzene simply because there's no absolute scientific evidence, then the standard of proof that the court is setting is dangerous. And if the standard of proof that's set by the courts is one of absolute scientific proof, and that standard cannot be met without longitudinal studies, we create a culture in which ignorance of harm is equated with lack of harm, which is an appalling outcome.
But counsel, isn't the opposite also true, that if you set too low an evidentiary burden on the plaintiff or the claimant, then you're punishing government actors who haven't done anything wrong in the absence of any actual harm or any actual evidence?
I was going to follow up on that. Is in terms of a court, don't we base our decisions on evidence? And if we don't have any evidence, how can we possibly find there's harm?
We do base our information off of evidence, but we also don't need absolute scientific proof for everything. In fact, what we have so far is as follows: that benzene, we know that benzene, even at low level, is known to cause extremely harmful and negative side effects, and that it causes long-term damage to the body even after the period of exposure has ended. And we already have this information, but we just don't have a specific scientific standard of proof.
Sorry, well, what is that evidence that significant harm is done with small quantities of benzene? What is the evidence that you have then?
All our evidence comes from testimonials from specialists and research that we've done, and is in our factum in paragraph 60 and onwards.
So you're saying then that you do have scientific evidence and that you do have expert evidence that will testify that in this case, there has been extreme harm resulting from these small amounts, relatively small amounts of benzene.
We have proof that benzene can cause this. We just don't know if benzene caused it in this situation specifically. And we can't tell if benzene has caused it in this situation specifically unless we have longitudinal studies. And these studies take upwards of 50 years and are done by discovering how benzene poisoning has effects on similar communities. And we just don't have 50 years to research all this.
Right, fair enough. Thank you.
So may I continue with the information that
Certainly,
we do have?
That was helpful, thank you.
Mm-hmm. So we know that the health effects are consistent with the known effects of benzene exposure, and these have been observed in the deer river population. Third, these harms are magnified by exposure to benzene at higher levels. And finally, the director's decision increases the environmental benzene levels in the Deer River Reserve to 4 times their allowed levels for a period of 5 years. And we submit that this is sufficiently compelling evidence that the director's decision will have a large and direct impact on the health and bodily autonomy of Ms. Archibald. Now, our friends submitted in their factum that Section 7 does not protect against the government increasing the risk of harm. We provide here the following response. The mechanism by which benzene causes health problems is through cellular and respiratory damage. Regardless of whether or not these damages result in cancer or asthma specifically, it still has long-lasting impacts on the length and quality of life of those affected. This is a matter of substantive, experienced effect, and not abstract, calculated quantity of risk. We would also like to specifically address that the lower court's characterization of Ms. Archibald's case as demand for positive right. We highlight in the analysis, starting at paragraph 75 of our factum, And we detailed that first, the creation of site-specific guidelines constitute both procedurally and substantively the creation of novel policy. And second, that the ministry should be treated as a decision-making body, independent of the legislature, and that their decision to withdraw protection should be viewed as an independent exercise of power. We would submit that Ms. Archibald is demanding a negative right against government policy that causes harm, instead of government inaction. Now, while discussing gross disproportionality, we have to weigh what the government did and what they tried and what they achieved to see whether or not it was reasonable. The director's decision caused harm to a group of people in a way that has greatly infringed on their Section 7 rights. The director made this decision to ensure that RUCAN's profitability would be maintained in the short run. This is not a trade-off that the government should be making, as it aggressively favors RUCAN and does not acknowledge the diminished quality of life of Ms. Archibald and the Deer River community. It's imperative to understand that the precedent being set here is inconsistent with the values of the Truth and Reconciliation Board of the Canadian government. My partner will discuss this further in his analysis of issue 3, but the public interests here are substantial enough that this decision should be overturned. Thank you.
Thank you.
Apologies. Can everyone hear me?
You're a little soft, but...
Oh, apologies. Justices, my name is Heather, initial A, and I will be presenting our Section 1 case, as well as responding to any questions for the previous submissions. The proper standard under which to perform a Section 1 analysis of an administrative decision is a standard of reasonableness, which should weigh the goals of the ministry against the charter infringements committed in pursuit of those goals. With this in mind, we make two submissions. One, that the director misapprehended their enabling statute and the contextual factors with which they were faced. Two, that those misapprehensions led to an unreasonable weighing of the ministry's competing aims. Under the EPA, what is required in order to grant a site-specific standard is a claim of either economic or technological necessity. Examining the testimony provided by the director, the ministry's finding of economic necessity seems to have been based on two primary factors. One, should the company be forced to temporarily reduce their production in order to meet the standard, they would be forced to temporarily lay off a total of 50 workers, or 6% of their workforce. Two, the economic strain of this decision would be such that the company, which has been operating in the area for decades through several major economic crises, would be forced to incur the expense of completely relocating their production out of province. Given that the claim of economic necessity by the company must be released to the public under the EPA, we can assume that this information is all we have to work with. With that in mind, this case seems to be one not of a major employer in financial distress requiring government aid to stay afloat, but of a company seeking to avoid accountability for pollution while they retool so they can remain profitable. This is not a case of economic necessity, but one of bottom-line convenience. The EPA also demands that there be no compelling public interest reason to deny the request, thus necessitating a contextual review of circumstances. Yet in their provided reasoning, the director makes no mention of the long-term impacts of benzene on the community, the constellation of factors mentioned by our expert witness, nor the effect that an increase in benzene may have to aggravate those long-term chronic health issues.
Counsel, on the point of economic necessity, is it your submission then that the business's viability is the standard by which we should measure economic necessity? That is, unless the business will die because of absent government intervention, they've not met that standard, or if not, what standard are you submitting? It
is our submission that in cases in which there is, as we have sort of detailed in our previous submission, in which there is large risk to physical risk to the inhabitants of the area in which there are charter concerns, it is important that the definition of economic necessity be, tailored such that it only includes either a substantial disruption to employment in the community, i.e., like the community economically would experience a substantial blow should this exemption not be granted, or in the case, environmental viability. We simply do not believe that a, layoff of 50 people, a temporary layoff of 50 people at a, company, at a factory employing 900 people in a place where there are other economic opportunities meets that standard of necessity, and that is proportional to the harm in which the government is engaging. I hope that answers
Thank you, counsel. Thank you. That's helpful.
Again, in their submission, the government also makes no mention of the disparities in access to healthcare and the existing health disparities in lifespan and propensity towards chronic disease of the community and of Indigenous peoples in Canada as a whole. Instead, the director insists that their decision is essentially harmless due to its time-limited nature. We believe this only makes sense if the sole concern of the director in this case is the physical presence of benzene in the environment. Sorry, can you still hear me clearly?
I can hear you for what it's worth, but I don't know what's happening with Justice Thorburn.
This is Justice Lacornic, and I can hear you still also.
Apologies. If Justice Thorburn cannot hear me, I can just go back to the last part she heard. I'll just wait for her response. Shall I wait for her response, or?
Yeah, let's just wait a minute and see if. Oh, Thorburn, are you back?
No, she's. Let's. Oh, yeah, I think she might be back. Let's pause it until we're sure.
Hello.
Certainly.
Okay.
We can hear you, Justice Thorburn.
Good, perfect. I don't know what happened. I was having difficulty hearing just the last few minutes.
Apologies. What was the last piece of my submission you heard?
I think just before Daniel was about to interject.
Apologies.
I wasn't about to interject, so you can just continue off. Just go back a little bit and continue off.
Instead of making mention or taking into account the systemic disparities or the additional harm that would be laid upon the community based on contextual factors, the director insists their decision is harmless due to the time-limited nature of the increased emission. This only makes sense, is our belief, if the sole concern of the director was the physical presence of benzene in the environment, which, as my co-counsel has stated and I will restate, is not the primary issue in this case. The issue here is the damage caused by benzene to the sort of like physical bodies of the inhabitants of the region, not the physical presence of it in the air. One is time limited and breaks down. The other one is lifelong and multi-generational. These fundamental misapprehensions, is our belief, failing to consider the economic injustice perpetrated upon the community over the last 50 years and of Indigenous communities altogether, as you will see in our factum, and failing to correctly interpret the doctrine of economic necessity, giving it overbroad jurisdiction, produced a profound disparity between the goals achieved by the ministry and the charter violations committed in pursuit of those goals. The director's decision has perpetuated existing health disparities between Indigenous and non-Indigenous communities, exacerbated generational trauma, and continued Canada's history, as you will find in the section of our factum dealing with reserves, of abandoning its fiduciary responsibilities and forcing Indigenous people to make a choice between residing on their lands and preserving the health of them and their children. All of this was done to save 6% of RUPAN's workforce, 50 jobs. To us, that seems unreasonable. In closing, we ask that you consider this case in its broader context. The framework the government wishes you to endorse is one in which contextual factors, the history of pollution in an area, have no bearing upon administrative decisions, which, given the charter is implicit in administrative decision-making, is no small change. It removes the, essential quality of necessity from economic necessity, turning site-specific exemptions from exceptions to the rule to default options. As whenever there is a spike in pollution, it is usually something that would be costly to the company to remedy. More worrisome, it deviates from the message and goals of the Truth and Reconciliation Commission, forever affirming as established in the affidavit of Miss Archibald and of Murray Cavan, that Indigenous lives are fundamentally worth less to the Canadian government than company profits. For these reasons, we ask that you allow this appeal and reverse the director's decision.
Thank you, Councillor. Are we ready now to hear from the respondents?
May I begin?
Yes.
Okay. Good afternoon, Justices. My name is Anna Krakowski. My colleagues are Anna Sophia Rashid Cocker and Jana Van Heesvik, and we are counsel for the respondent's case. The appellant submits that Ms. Archibald's Section 7 and Section 15 charter rights were violated by the director's decision and are not saved under Section 1. While Ms. Archibald raises many of her concerns, we respectfully disagree. We will be submitting 3 arguments today. First, we submit the director's decision did not infringe Ms. Archibald's right to equality under Section 15 of the Charter. There is no explicit link between the director's decision and any discriminatory purpose or effect. Second, we submit the director's decision did not infringe Ms. Archibald's right to life, liberty, or security of person under Section 7 of the Charter. We have not seen concrete evidence showing how the director's decision causes death or an increased risk of death to Ms. Archibald. Nor is there a causal link between the benzene and any harm on the claimant. On the contrary, the director's decision will increase economic activity and reduce net emissions in the St. Pierre region over time. And finally, we submit that if any infringement of Ms. Archibald's charter rights are found, the infringement is justified under Section 1. The director's decision puts multiple factors into account and did her best to balance the competing needs of the economy, the environment, and local communities. It is respectfully requested that Justice Carter and Justice Sen's ruling in this case be upheld, as we submit there have been no justifiable charter infringements. I now invite you to listen to the rest of the respondent's case. Thank you.
Hello, can everyone hear me and see me?
Yes.
Okay.
Yes.
May I begin?
Yes.
Good afternoon, Justices. My name is Jana Van Heeswijk, and I will be presenting Issue 1 of the respondent's case. By analysis of Section 15 using a 2-part test, as established in Kakiwistaha First Nation v. Tapatat, we submit that there are no infringements upon Ms. Archibald's right to equality. The test consists of 2 questions. The first asks, does the law create a distinction based on an enumerated or analogous ground? Under Section 15, Indigenous individuals are protected from discrimination on the basis of race, nationality, and ethnicity, and there is no evidence that the director created a distinction based on these grounds. The Roucan plant operates in the village of St. Pierre, 5 kilometers away from the Deer River Reserve. Thus, the operations of the factory are just as relevant, or perhaps more so, to the residents of St. Pierre as they are to those of Deer River. While there is no doubt that Indigenous communities are historically disadvantaged the appellant has failed to demonstrate a connection between the director's decision and any discriminatory effects on the basis of her race, nationality, or ethnicity. Next, we ask, does the distinction create a disadvantage by perpetuating prejudice or stereotyping?
Counsel, sorry to interrupt you. I just have a question about the distinction point. So one of your colleagues on the other side was saying that Indigenous people have a close connection to certain lands and territories that makes it such that they maybe shouldn't be forced to leave and go somewhere else. So I think your analogy to the town that's also close to this plant is not maybe fair, because people in that town can just decide to leave, and that doesn't put them at some kind of disadvantage or require them to forsake their identity. Whereas we can't expect the same of the Indigenous group on the reserve. Is that correct? Do you agree with that understanding, or am I misunderstanding it?
Actually, the right to liberty is, and that specific point touched on Miss Archibald's connection to her land and her ability to leave is actually touched upon by my colleague in issue 2, in that the right to liberty is not infringed upon, and actually I'll leave that for her to get into in the issue 2. Okay, does that maybe I don't understand what you're asking.
My question was more just that to my mind, it does seem to me like it creates a distinction if what's happening is that we're asking a certain group to, I guess my point is basically the Indigenous group that lives on this reserve is impacted by this decision in a way that people who live in the town are not, right? And if that's the reality, then it does seem to me like the law is drawing a distinction. Even if the law isn't specifically in the reserve, it's impacting people in the reserve differently, or rather the decision of the decision maker.
Right, but I'm just going to continue here because my next point sort of touches on that, and that even if you do find a distinction based on those grounds, the second question, if the distinction perpetuates prejudice or stereotyping, it will not stand. So I'm going to continue with that. So while recognizing the historical disadvantage faced by First Nations communities in Canada, there is no evidence that conclusively demonstrates that the director's decision aggravates that disadvantage. Dr. Pagnutti indicated that benzene emissions could not be concretely linked to the health effects experienced by Deer River residents, and Dr. Bastarache conceded that it is very unlikely that the temporary increase in emissions would increase serious health risk. In Kakiwistaha First Nation v. Tabatat, it was established that a clear correlation between a law and its effects is necessary to determine discrimination. Thus, a claim of discrimination on the basis of perpetuated disadvantage cannot be determined based on the inconclusive evidence available. So even if you do find a distinction based on, for the first question, the second question, it will be found to be answered in the negative. Finally, the appellant has raised concern regarding the lack of insight into the director's decision-making process. However, it must be considered that the decision was made after an extensive public consultation process in which Ms. Archibald participated. The decision was also made following the requirements of the EPA and in accordance with its values of preserving long-term environmental and economic prosperity, a component of which is preserving job security for the 275 Deer River residents who work at RUCAN. In Newfoundland and Labrador Nurses Union v. Newfoundland and Labrador, it is emphasized that a wide range of specialized decision makers render decisions in their respective spheres of expertise, rendering decisions that are often counterintuitive to a generalist. Thus, we must consider the director's role as a specialized decision maker. Although it may seem counterintuitive, the director's decision is not.
Let's just wait a moment because it looks like Justice Thorburn has left the meeting.
Oh.
so yeah, sorry to interrupt you.
That's fine.
Let's just give it a moment.
third point. So the appellant has raised concern regarding the lack of insight into the director's decision-making process. However, it must be considered that the decision was made after an extensive public consultation process in which Ms. Archibald participated. The decision was also made following the requirements of the EPA and in accordance with its values of preserving long-term environmental and economic prosperity, a part of which is preserving preserving job security for the 275 Deer River residents that work at RUCAN. In Newfoundland and Labrador Nurses Union v. Newfoundland and Labrador, it is emphasized that a wide range of specialized decision makers render decisions in their respective spheres of expertise, rendering decisions that are often counterintuitive to a generalist. Thus, we must consider the director's role as a specialized decision maker. Although it may seem counterintuitive, the director's decision is not inherently discriminatory towards Ms. Archibald and was made with the long-term benefit of all parties in mind, including the Deer River community. Okay, I don't know that. Thus, it can be concluded that the director's decision does not constitute discrimination based on Section 15 of the Charter. Thank you. I now turn it over to Anna Sophia.
All right, may I begin?
Yes, you may. Thank you.
Good afternoon, Justice Thorburn, Justice Lickwarnick, and Justice Cisgorio. My name is Anna Sophia Rashid Cocker. Today, I will be presenting Issue 2 of the respondent's case. Using a two-stage analysis of Section 7, we submit that there have been no infringements upon Ms. Archibald's right to life, liberty, or security of the person. First, we must ask, has there been a deprivation of the claimant's life, liberty, or security? To apply Section 7, as established in Operation Dismantle, a causal link between the government's actions and a violation of a person's security. Dr. Pagnuti confirmed that there is no certainty that benzene emissions are responsible for any of the impacts observed on the Deer River First Nation. Even our friends, the Counsel for the Appellant, could only offer that the facts from the Australian Department of Environment, as stated in paragraph 69 of their factum, would suggest that benzene pollution in the atmosphere can cause severe and irreparable harm. Members of the panel, a suggestion is far from proof of causation and is insufficient evidence for a Section 7 claim. Furthermore, Dr. Bostaraj conceded that the likelihood that RUCAN's site-specific standard would increase the risk of cancer in someone is extremely low. For a Section 7 claim that the right to life has been violated, the state action must impose death or an increased risk of death on the claimant. An exceptionally low risk of cancer is not necessarily an increased risk of death. Therefore, it is evident that there has been no violation of Ms. Archibald's right to life or security of the person. Now, for stage 2 of our analysis, we ask, if there is a deprivation, is it justified in accordance with the principles of fundamental justice? While we recognize the significance of the land to Ms. Archibald and her community, her right to liberty has not been compromised. In Alberta v. Cunningham, the court found that there is no need to decide whether a place of residence is protected by Section 7, as there are no impacts on liberty contrary to the principles of fundamental justice. There was consultation with the affected community before forming out legislation, so the actions of the government were not grossly proportionate to the issue. In our case, the director conducted a broad public consultation with the community and stakeholders as per Section 35 of the EPA. And it should also be noted that some members of the Deer River Reserve community did support the decision. So, following the precedent from Alberta v. Cunningham, we submit that there has been no infringement upon the claimant's liberty. Finally, It must be stated that the Charter does not confer a freestanding right to a clean environment, nor does the government have any positive obligation to Ms. Archibald under Section 7. We submit that as there's been no infringement upon the claimant's rights, the government has no further responsibility to Ms. Archibald on the matter. Thank you.
Sorry, I was just about to interject with a question, but my microphone was off. Counsel, so as I understand your submissions, is it really your position that none of the rights that are protected under Section 7 have been breached? That neither life, liberty, nor security of the person are even engaged in this circumstance?
Sorry, do you mind repeating the question?
Sure. So as you know, Section 7 of the Charter deals with the right to be not to be deprived of life, liberty, or security of the person, except in accordance with the principles of fundamental justice. So usually the way the analysis works is you say, are these rights engaged? Like, is someone's right to life or right to liberty or right to security of the person engaged? And was that not in accordance with the principles of fundamental justice? Did I understand you correctly to be saying that none of those three rights were at all engaged, that the action of the government didn't impact on Ms. Archibald's claim or rights with respect to either of those three? Does that make sense?
Yeah, so I guess, so Ms. Archibald had a claim that it was all three of those were impacted. And I guess what I said today was that her right to life and security of the person are not engaged, as there's no causal link that ties the director's decision to a violation of her security of person, and then as well that the right to life is not engaged, as the state action doesn't impose death or an increased risk of death. As for her liberty, I found that it was based on essentially the same thing that happened in Alberta v. Cunningham, where members of the Métis community were discussing whether their place of residence and whether they were able to stay on their place of residence was an infringement upon their liberty. The courts found that since before, like the legislation surrounding that was formed with consultation to the community beforehand, so that it was saved under the principles of fundamental justice. So in our case, essentially the same thing happened as per the EPA, the director conducted a broad consultation first. So I guess essentially what I'm saying is that the first life and security of the person are not engaged at all, and then liberty is saved under the principles of fundamental justice.
Okay, that's very helpful. Thank you.
I have another question. You talked about the fact that there was no evidence of an increased risk of death, but isn't that placing an unrealistic hurdle on these people? Because your friends pointed out that it would take 50 years to get that specific evidence to create that verifiable causal link.
I think that it is. While I understand that maybe that specific like 50-year test is not really reasonable, I think we can look at the testimonies from the experts, Dr. Pagnuti and Dr. Bastarache, to point out that, one, it doesn't stay in the environment for a very long time. There's no real connection there between that the benzene necessarily has an impact on the community. And as well, even with the facts that they brought in from other sources, as I mentioned earlier, that even those facts could only really suggest that benzene pollution in the atmosphere could cause severe and irreparable harm. And I think for a Section 7 claim, you really need a little bit more than a suggestion, even if you don't necessarily have that 50-year long test. Does that make sense?
So what else could you have? your friend is suggesting that the only other thing, and we know that this is a product that harms people in small doses. We know that it was present there. We know that there are some symptoms that have been exhibited by this individual and other members of her community. So what else other than the 50-year study would you need to satisfy you that there actually is an increased risk?
That's a good question. I'm just gonna, do you mind if I just take a minute here?
Of course. You can take your time.
I think that even if you don't have a 50, like an extensive test, the fact that there's like no certainty, and then the fact that the risks have been extremely low, as highlighted by the doctor, and as well the fact that the benzene doesn't remain in the environment for a very long time. Certainly, also, like, even if you have the test, the other components I think also add to that. So, yeah, does that?
All right. Thank you.
Thank you.
Hello, members of the panel. Now I will be presenting issue 3 of the respondent's case. I will be using the Oakes test to illustrate how the province's actions are demonstrably justifiable in a free and democratic society. In the interest of time, I'm going to skip over to the more controversial matters within this issue regarding proportionate effect and minimal impairment. First, let us address the question of proportionate effect. The appellant submits that RUCAN would be viable without the site-specific exemption. We respectfully disagree, because the viability of RUCAN without the site-specific standard is not clearly stated anywhere. RUCAN initially applied for the exemption because something went wrong with the new greener machinery they wanted to install. The only plausible explanation for RUCAN's plan to increase production by 35% is that their demands must also have increased. The director's decision ensures that RUCAN can keep all of its employees and benefit the local environment in the long run. The counsel of the appellant claims that laying off only 50 employees is not significant. Although it's only 5% of the entirety of the employees, this can be as high as 18% for the employees who are also Deer Park residents.
Counsel, I want to put to you the same question that I put to your friend, which is, what would you submit is the standard for economic necessity? What is the appropriate standard in your submission?
Well, I believe that I think there are multiple factors to take into account here, because it seems like RUCAN did their due diligence to look at multiple factors. They wanted to increase their production, but at the same time, they wanted to keep all of their employees so that they would have job security, and as well, they'd like to benefit the environment in the long run so that they can still meet the standards while fulfilling everything else.
So that's obviously what your client would like, but or what RUCAN would like the standard to be, keep all of the employees. But is that actually your submission, that if any employees are to be lost, that meets the standard of economic necessity?
Well, I think that the question of whether they're of economic necessity is not for me to prescribe at this moment, because there's so many factors to take into account there.
Okay, thank you.
Okay, to continue, Mr. Bastarache previously stated that benzene degrades rapidly, that benzene does not remain in the environment, in air, soil, or water for long periods of time, and that the likelihood of the site-specific exemption increases Miss Archibald's risk of cancer was extremely low. The appellant claims that the benzene emissions would not dissipate from the bodies of those people who have been exposed to elevated benzene levels. Yet, according to a Priority Substances List assessment report on benzene released by the Government of Canada, benzene is a non-persistent and non-bioaccumulative substance, which means that it does not accumulate in humans, animals, or other organisms over time. In other words, the increased benzene emissions at present will not impact Miss Archibald significantly in the future. Second, let us address the question of minimal impairment. Section 35A of the EPA states the exemption made must be the minimum difference necessary to fulfill Section 20 of the EPA. In Newfoundland and Labrador Nurses Union versus Newfoundland and Labrador, it clearly states that specialized decision makers render decisions in their respective spheres of expertise using concepts and language often unique to their areas and rendering decisions that are often counterintuitive to a generalist. The director has the most expertise in her field and thus has the best judgment on the subject.
Counsel, I appreciate your looking at sort of the expertise of decision makers by the government, but the whole point of the charter is to constrain what the government is able to do. And so...
Hello?
Yeah, we can't hear you, Daniel.
Saying that those people are experts and they know better than we do is not very comforting to people who are directly affected by those decisions. So should we really be adopting? Oh, can you hear me now?
Yeah. Well, although I see your point in how we shouldn't always rely on the experts, we have to take into account that even before the director came to her concluding decisions, that she did multiple consultations, and the residents of the Deer Park Reserve were also there, so she had to take multiple factors into account with her decision. She didn't make it solely on her own. Yeah? Okay. May I continue?
Yes.
Yes.
Alright, to conclude, we submit that any infringement is justified by Section 1 of the Charter. It is respectfully requested that Justice Carter and Justice Sen's ruling in this case be upheld, as we submit there have been no justifiable Charter infringements. Thank you for listening to our arguments today.
Thank you.
Okay, so there won't be any replies, so I believe that concludes the submissions. The court will now adjourn for 10 minutes for the panel to make deliberations to provide feedback.
Okay, well, welcome back, everyone. Thorburn here. Can you hear me?
Yes.
Can you hear me?
Yes.
Yes.
You can hear me?
Yes.
Okay, perfect. Welcome back, everyone. And I want to apologize as probably the oldest person on this call and the least proficient, at least today, in terms of this new technology. But I wanted to say I'm going to use some words that Daniel Siscorio used when we were in our breakout session before we came back to you, that you guys were, in his words, shockingly good. Honestly, I know how much time and how much work you put into these things,
And I really, really wish we had been able to see you and to hear you in a real life courtroom. But I think you did a wonderful job. And one of the things that I think you did really well was you were able to adapt to these unusual circumstances and some of the challenges that we've had in dealing with the technology today, and not let it knock you off your game. Because you know, whether it's a problem with technology or it's a problem with the judge that's in front of you being in a crabby mood or something else, there can always be something that can potentially throw you off your game. So it's really, really important to know your material so well that you are sufficiently nimble to be able not to be knocked off your game. And I think all 6 of you did that admirably. I want to say that I think I speak on behalf of all 3 of us when I say that you were very good communicators. You were calm, you knew your material, you were able to respond to questions. You didn't tell us, well, I'll get to that in the next 15 minutes. You responded to it, and you responded to it well. You had a calm about you. And so any comments that we offer you are very, very small points to improve what are already excellent performances. I guess, Adil, I'm going to start with you. You had a very lovely, calm manner. The only small thing that I would mention is that this is a conversation, and you did what actually I do a fair bit, which is I like to have my hands moving and whatever. So just be cognizant of that sometimes it can be a little bit distracting when somebody is when that happens. And Anna, I know you were very good at the argument and responding to things. I think you might want to just slow down a tiny bit. But I think all of you had very good eye contact. All of you had very good communication skills. And I think all of you really dealt well with the difference between oral argument and a factum. Because for me, a factum is a speech. Things that are said the way you want to say it in a very comprehensive way. By contrast, an oral argument is a conversation. There's a back and forth, there's a to and a fro, there is a panel that may be interested more in some issues than others, and you have to deal with that, and you did that admirably. So I think you and your teachers should be very, very proud of yourselves. And I certainly was really, really blown away. So I wanted to thank you very much for that. And I think that Helena and Daniel may have a few other comments that they want to make. And if there are any questions that you have, this is your opportunity to ask. So we'll finish off by letting you ask a question if you would like to do that. So Daniel, Helena, do you guys have anything you wanted to add?
This is Helena Liquornik speaking. I'll just add a few comments. Absolutely thought you guys did a great job, really clear submissions, and you took advantage of what I always like to remind people are the opportunities of questions. So questions are naturally nerve-wracking because you haven't prepared for them exactly in advance, but you should really try to see them as your friends because they let you know what the panel's thinking, what is concerning them, and they're a great chance for you to actually win over the panel and help the panel get over a hurdle that they might see to accepting your argument. And all of you really did a fantastic job. We all thought of responding to the questions and helping us get over those hurdles in terms of accepting your argument. And that also sort of speaks to the point that Justice Thorburn made, which I think cannot be overstated, about resilience. So we had technological challenges today, but I mean, I have yet to see an appeal where there isn't something unexpected that comes up, a question that you weren't really, the council wasn't quite expecting, a document that the panel wants to look at and you don't know where it is. And, there's always something. So Justice Thorburn, when the three of us were chatting, mentioned the concept of resilience. And I just wanted to sort of echo that because I thought that was such a good word for what counsel are always required to have. And all of you really demonstrated it admirably. I just had one tiny point that I thought I might add in, which is a number of you used terms like I believe or I think, and the way that we usually distinguish between counsel's own beliefs and thoughts, which might actually be different from whatever position it is that they have to put forward in advocating for their clients, is I submit. So, and it's a very useful phrase to use because, you might not personally think that something is the case. It might not be your personal. You're advocating for your client. So a great way of sort of making that clear is I submit. And often sort of the panel will put to you a question like, are you seriously saying that such and such is the case? And it might be somewhat aggressive. That's kind of the panel members suggesting that they don't actually agree with that. Well, a nice way to handle it is, yes, that's my position, or yes, I'm submitting that. And that sort of separates you from the position that you as an advocate are taking. Anyway, wonderful, wonderful job. Thought you guys did phenomenally well. That's it for me.
So I guess I'll chime in a little bit. I agree with what has already been said about just how excellent and thoughtful all of your submissions and arguments were. One thing that I want to highlight that I think everyone did really well is just knowing both how to take positions that are very, very reasonable and knowing when to kind of concede or let go things that you don't absolutely need in order to win your argument. I thought that you all did that really well. And I think in this type of advocacy setting, some people might have the instinct to just argue about every single point that can be argued. And all of you did not do that. All of you instead specifically decided which points were arguable and controversial and decided to talk about those rather than insisting on something where you really don't have that great of an argument and recognizing when it's an argument that you don't even need to make in order for your point to really come across. So I thought that you all did that really, really well. And just generally, I'm probably the youngest non-student here. I graduated from high school exactly 10 years ago. So I was just thinking to myself throughout this whole thing that I wish I was as eloquent and thoughtful as you guys are at this stage in your education and schooling. So I thought this was all really, really impressive today. And I'm certain that there's a lot of good stuff kind of in store for you all in your futures and in school and beyond that. And also, if you are interested by what you saw today and want to become lawyers, you absolutely should. So I guess since we've finished our own feedback, if there are any questions from anybody, please, I guess, turn on your video and unmute yourself and go ahead.
I'll just briefly interject. This is a great opportunity to ask any questions about the legal profession or our jobs. Justice Thorburn is, of course, a judge, and Helena is a staff lawyer, and Daniel is a law clerk. And so please feel free to ask specific questions about your educational goals and careers. We're all happy to answer those types of questions.
And of course, you shouldn't feel the need. You've worked really, really hard and you're probably exhausted and wanting to get out and enjoy this lovely day. So if you don't, that's also fine too. And we just wanted to say how what a pleasure it was to have such excellent advocates appear before us today.
I just have a single question. Oh, do you want to go first?
Go ahead.
Okay. First of all, thank you so much for the feedback. It's very helpful and it teaches us a lot. but I just wanted to ask, because I was thinking of going into law, but I don't know, like how I should think of my pathway if I'm going to go into something that, like, if I'm going to go into a post-secondary education that doesn't really align with law too much. Because I was thinking of doing something like maybe in the sciences for a bachelor's degree and then going into law. And I just want to see whether, like, what are some challenges with that?
Well, I guess I should say that I'm probably not the person that you should be asking this to, because I did my undergraduate in opera. So that's about as far away from law as you could possibly get. And I did no academic courses. All I did was sing and play the piano. So I really do believe, though, that you should study something that you love, something that you're passionate about, and something that you're good at. And it really doesn't matter whether it's the sciences or not. And one of the reasons for that is that law is a very broad field. So law encompasses everything from, for example, reviewing patents, where having a scientific background is extremely important, to construction liens, to policy advice, and all sorts of things. So I don't think you should feel that you're limited to, studying political science, economics, commerce, whatever. And frankly, I think in many ways, other subjects can be an interesting addition to what you have to offer to a potential law school. And I have to say that, some of the best law clerks that I've had, some of them have done science. So I don't think that's a bad choice at all. And if that's what interests you and that's what you're good at, that's what you should do. It also leaves options open, because sometimes people think, oh, I desperately want to be a lawyer when I'm, in grade 12, but by the time I'm in third year university, maybe I've changed and but if you're studying something that you love, there are many different opportunities, one of which is law, but there may be others, and you may decide at that point that you want to pursue your love of science in different ways.
Mm-hmm. Thank you so much.
Was there another question?
I was going to ask for the students, just because of my conversation with them, the questions you get, students aren't necessarily prepared for them in that moment. Is that something that you sort of develop over time? Is there like a strategy that people take in terms of, do you ask yourself questions that you would normally think about in related to this case? Like, how do you kind of develop that acumen to be able to sort of answer on the spot and pivot in those moments?
Okay, Daniel and Helena, feel free to step in, but I'm just going to say briefly that I think part of it is Jack be nimble, Jack be quick. If you know your material well enough, you know it backwards, forwards, and inside out, then you'll know how to repackage it and look at things. You never know exactly what questions are going to be asked, because quite frankly, maybe somebody's off on a tangent that really isn't relevant and is kind of a stupid question, but they ask it anyway, and you have to answer it. But I think that preparation is key. And I do think that one thing that you can do is look at your own argument and say, what are the weakest points in my argument? Because those are likely going to be the field where people are going to be trying to look at questioning you. And so that's a good place to start. Daniel and Helena, I don't know if you have anything you want to add.
Yeah, I would just say that's one of the things that preparing entails, is sort of looking at your argument and asking yourself, as Justice Thorburn says, what are the weak points? What are the things that are less clear about this case? What are the things that, if someone were to accept my position, what would be the biggest obstacles for them? So just posing those questions to yourself about your own argument will help you prepare for questions that you are likely to get. And the other thing is, it is totally acceptable to take a moment in a hearing. If a question is posed to you and you need to collect yourself, you absolutely can say, court's indulgence, a moment please, and take, you can't take a long time, but you can take a moment to sort of gather your thoughts and then respond if it's a question that you really haven't haven't expected. But preparing by asking yourself those questions and, you know, having colleagues look over, or, you know, preparing with colleagues can help with that as well.
I think Anna Sophia showed us that as well. I mean, you were asked a question, you needed to take a minute, and it's much better to take a minute, think it through, and give a coherent, thoughtful answer than to try to rush yourself into giving an answer in the first 3 seconds that may not be so well thought out.
Yeah, and I think as a specific pointer, I think something that's probably your best friend in terms of thinking of which questions you're going to be asked is the factum of your opponent, because I think they'll have poked holes in every part of your argument, and the things that they identified as problems are a good indicator to you of things that someone might think aren't as strong about your own argument. And another piece of advice is just kind of think about the consequences of your argument and what your argument is saying. So if you're saying something like, oh, we can't impose a big evidentiary burden on the claimant or the plaintiff, you might be saying in that, as a consequence of that, that someone might be found liable for something when they aren't in fact responsible for it. So I think you need to just be anticipating sort of where the slippery slopes are of your argument, what your argument can lead to if you're not careful about it. And by identifying those, you might think of questions that you might be asked.
Thank you. I apologize, everybody. I have another hearing that I have to join in on at 1:15. So thank you all so much. You really did a wonderful, wonderful job. And I look forward to seeing some of you at our court someday in the not too distant future. Thank you.
Thank you.
Thanks.
Thank you, Helena. And I just wanted to take the opportunity to thank all of you again for all of your hard work. And I echo her sentiment in saying we really look forward to seeing you in another capacity in a few years. So I guess we're going to let you all get some lunch and enjoy. Thank you very much.
Excellent.
Thank you for
Thank you very much, everyone, for your patience. Thank you for everything. And
thank you.
Thank you.
we'll see you all soon.
Thank you.
Thank you.